What is trustee self-dealing? Have you ever wondered what happens when a trustee puts their own interests above those of the beneficiaries? This situation is known as trustee self-dealing, and it raises serious ethical concerns in estate planning and elder law. Let's break it down. Trustee self-dealing occurs when a trustee, who is responsible for managing a trust's assets, acts in a way that benefits themselves rather than the beneficiaries. This behavior is a violation of the trustee's fiduciary duty, which requires them to act in the best interests of those they serve. At its core, self-dealing means using trust assets for personal gain instead of for the trust's intended purposes. For example, a trustee might claim excessive fees for their services, far beyond what is reasonable. They might also invest trust assets in businesses where they have a personal stake, regardless of whether those investments benefit the trust. Another common example is when a trustee sells property to the trust or buys property from the trust at unfair prices. This could mean selling below market value or purchasing at inflated prices. Additionally, borrowing money from the trust for personal use or making gifts to themselves from trust assets are clear signs of self-dealing. Mixing trust assets with personal funds is another red flag. If a trustee receives kickbacks or undisclosed benefits from third parties paid by the trust, that is also a serious issue. When a trustee is also a beneficiary, they may distribute trust assets in a way that favors themselves over other beneficiaries, which can lead to conflicts of interest. However, not every transaction where a trustee benefits personally is considered self-dealing. If a trustee who is also a beneficiary receives distributions equally with other beneficiaries, that is generally acceptable. The key factor is whether the trustee gains an unfair advantage or acts against the interests of the trust or its beneficiaries. From the perspective of elder law and estate planning, trustee self-dealing is a significant breach of trust. Trustees are expected to manage the trust fairly and avoid conflicts that could harm the beneficiaries. When self-dealing occurs, it can deplete the trust's assets and lead to legal disputes. Beneficiaries who suspect self-dealing should seek legal advice quickly. Recovering lost trust assets can be challenging once they have been misappropriated. Courts can remove trustees who engage in self-dealing and may requiring them to repay any losses to the trust. In summary, trustee self-dealing is any action by a trustee that benefits themselves at the expense of the trust or its beneficiaries. It violates their duty of loyalty and care, undermining the trust's purpose and leading to serious legal consequences. Understanding these issues is vital for anyone involved in estate planning or elder law.